Hello, and welcome to Filing a Claim for VA Benefits, brought to you by CalVet, CalTAP, and presented by Swords to Plowshares. So starting with the basics. The application process for VA benefits can be complicated and frustrating. So we encourage you to contact your local CVSO, County Veteran Service Office, or a nonprofit Veteran Service Office, or other legal resources to help you with your claim. You'll find them on the CalVet website. So what is service connection? Service-connected disabilities include any illness or injury that occurred or was exacerbated during active duty service. So during the entire time period when you were on active duty service, any illness or injury. It can be an illness or injury totally unrelated to military service. It just has to have happened while you are on active duty. So for example, cancer manifests. Doesn't have to do with service, but it happened during that time period. And don't forget, you can also claim for secondary conditions. So this would mean a condition that happened because of the service-connected condition. So if you have PTSD, for example, 10 years later you have heart disease and it's connected, then that heart disease can be a secondary service-connected condition. So there are different types of compensation and pension from the VA. Service-connected disability compensation is what we just talked about. There's also VA non-service-connected pension. We'll talk a little bit more about that. Survivor pension and or dependency and indemnity compensation. So this is when the veteran, the service member themselves has passed away and their spouse or minor dependents may get pensions. And there's also aid and attendance, which allows for more resources if you need help because of your condition. You don't have to complete a claim right after discharge. You can do it any time throughout your life, but you should if you can, because the evidence is fresh and your medical records are fresh and you don't have to dig into the distant past. Next, your disability doesn't have to be directly related to your military occupation. Again, it's anything that happened during the entire time you were on active duty. You can seek service connection for disabilities that occurred while on leave, while traveling to and from leave, while on base during off hours, while off base, anything. Again, it's the time period. Now this one's a little tricky. You are ineligible for GI Bill if you have a less than fully honorable discharge. But there's a pathway to this benefit through the discharge upgrade. So let's get started. So you can file a claim before you're even discharged while you're on active duty. There are options for filing if you have between 180 and 90 days left on active duty service. We're going to repeat this over and over again. Do not do this alone. Seek assistance. There's no reason for you to do this alone. There are accredited representatives. They are trained. They are approved by the VA, county veteran service offices, nonprofit VSOs, legal clinics hosted at VA sites, pro bono legal programs, all of these services, and they are absolutely free. It is actually illegal for anyone to charge you for help with an initial claim. So go ahead and get this assistance. It's out there, it's free, and it's easy to find on the CalVet website. So go to the eBenefits portal on the VA website. This is a portal where you can research, access, and manage your benefits and personal information. Now, it's a little bit tedious to create an account, but once you have it, it's easy to keep up and keep track of your records. You also have the date of intent to file preserved in the portal. We'll have more on that later. That's important. Now, I want to emphasize, we strongly encourage you to create an account, but we encourage you to do this while receiving assistance with your claim. So you can start all this at ebenefits.va.gov. So we'll talk about eligibility, VA pension eligibility. First question, were you discharged from service under other than dishonorable conditions, and did you serve on or before September 7, 1980? And did you serve at least 90 days of active military service with at least 1 day during a wartime period, or did you serve after September 7th, 1980? And did you serve at least 24 months or the full period on active duty with at least 1 day during wartime? So this is about having served during wartime. VA disability compensation. This, you may be eligible if you were active duty military service, Army, Navy, Air Force, Marines, Coast Guard, or National Guard members who were activated to federal service, paid by the federal government, active duty for training, or inactive duty training and you were discharged under other than dishonorable conditions and you are at least 10% disabled by any injury or disease that was incurred or aggravated during active duty training, or inactive duty training. That is a word salad, and that is why you should go get help. Less than honorable discharges. So if you have a BCD, bad conduct discharge, an OTH other than honorable, you may still be eligible for VA benefits if you apply for a VA character of discharge determination or a discharge upgrade through the Department of Defense Reviews and Corrections Boards. There's a whole module on that, discharge upgrades, module 7. You can see those materials and watch that module for more information. So now let's go into evidence. Now there are certain conditions for which the VA presumes disability. You don't have to have specific evidence proving this in your claim for the purposes of VA service-connected disability compensation. So these categories include, for example, veterans who were exposed to Agent Orange or other herbicides, those who are exposed to ionizing radiation, veterans who have certain chronic or tropical diseases that become evident within a specified period of time after discharge, veterans who are exposed to contaminants in the water supply at Camp Lejeune, North Carolina. So in these cases, these are conditions that we've learned over the years that are very likely to occur under these circumstances, and you don't have to prove, for example, a veteran with Agent Orange exposure that they were in one village on one day at 1 hour when they were exposed to Agent Orange. Instead, it's presumed based on the factors and the probability. Now, with most instances of service-connected disability that don't fall in those presumptive categories, you do have to prove that your injury or illness occurred or was exacerbated during service. And you want to avoid a lengthy appeals process, so submit as much relevant evidence as possible with your claim to really tell the story and show that your injury or illness occurred. So first, your DD-214, your official military personnel file, service treatment records, other medical records. Those include not only medical records that might have come from the VA, but private doctors. Now, you can also submit lay evidence. So this is not official records. This is evidence provided by witnesses, service members, buddy statements, people who have personal knowledge of the facts or circumstances that can be observed and described by that person. It's being described by a non-expert, not a doctor, but your buddy, your roommate, a friend, a spouse, a member of your family. Personal statements by these people is a great way to tell the story. Now, there's also the Disability Benefits Questionnaire, the DBQ. That's a form that the VA has that clinicians look through, and they specifically go through and decide compensation claims. They're designed to assist the clinicians when performing comp and pen exams, compensation and pension exams, which we'll talk a little bit more about in a minute. Now, There's more information on all of this kinds of evidence in the documents that accompany this module. Now, there are special considerations for some kinds of claims. So, for example, evidence in support of claims for post-traumatic stress disorder based on combat-related stressors. There are specific things that you need, including obviously a diagnosis and a history that is consistent with a combat-related stressor, that you were actually in conditions or deployed in conditions where such activities or combat stresses might occur. So we also have special considerations for evidence in support of claims for post-traumatic stress disorder based on military sexual trauma. Now, this is a situation where often there's not going to be a record if it was not reported at the time, and there are not going to be witnesses. That is often the case. So all sorts of other evidence that tend to show that a sexual assault occurred is allowable. And that can include a request for transfer to another military duty assignment, buying pregnancy tests or tests for STDs, statements from family members, substance abuse, episodes of depression, sexual dysfunction. So things that tend to show when there isn't actually any physical evidence and there were no witnesses. So let's go through the process. First is the intent to file form. Now this locks in an effective date and gives you 1 year from submitting the form to submit a formal claims application. Now if your claim is approved, retroactive benefits are calculated back to the date you submitted the intent to file. So that means more money. We mentioned this when we talked about filing in the e-benefits portal. That's why we said when you click that intent to file, when you file that form, that's when the clock starts ticking for your benefits. So the process. We're going to go through this rather quickly. It does take a long time, but you'll see that things actually happen during that time period. You file the initial claim with the VA. The VA receives the claim. You can check on that in the e-benefits portal. So next, it's under review. The VA assigns your claim to a veteran service rep for review to determine if additional evidence is needed. If they don't need anything else, your claim can move directly to the preparation for decision phase. But if they decide, the VA decides that they need additional medical evidence to decide your claim, they'll schedule a compensation and pension examination for you, a comp and pen or a C&P. Now, the Veteran Service Rep will also request evidence from the required sources. So they might be requests made to you, a medical professional, a government agency, other authority. It's common for claims to return to this phase should additional evidence be required. So this can go on. So let's talk about the comp and pen exam, the C&P exam, the compensation and pension exam. Now, this is just a doctor's appointment. Yes, it has to do with your claim and an evaluation of your injury or illness, but it is just a doctor's appointment. So you're going to go in. If it's a psychological injury, they're going to do some psychological tests. They're going to talk to you about how you feel and what's going on. If it's a physical injury, they're going to look at your records, your C file, which is a file of all of your medical records that the VA will have given to the doctor, and they're going to evaluate your physical condition. Back to the files, the doctor should have gotten the C file. The VA is going to make this appointment for you with a VA doctor or a private doctor that they contract with. If it's a VA doctor and they don't have the C file, they probably have access to your medical records on the computer in their office. If it's not, they won't, which is why it's a good idea to bring some documentation of your most important claim issues. You do not want to bring 300 pages. You don't want to bring your whole C file, but just in case, you'll have some of those documents that you can refer to. Now, one other thing. It's human nature to get nervous about this. Some vets clam up. Some other vets exaggerate. Both of those are bad ideas. Try to get there 10 minutes before. Get yourself into a calm state. Be honest with the evaluator, with the doctor. Tell them what's going on. Don't exaggerate. On the other hand, don't clam up. Don't suck it up. This is the time to actually say what's going on with a medical professional. So next, review of evidence. Once all the requested evidence received, the Veteran Service representative is going to review it. They're once again going to decide if more evidence is required, and if so, it's sent back to the evidence phase, the gathering evidence phase, for additional development. Moving on, preparation for decision. The VA service rep recommends the decision, prepares documents required to detail the decision. Next, pending decision approval. The VA reviews the recommended decision and approves the final award. But even at this stage, they can decide that more evidence or information is required and the claim can be sent back to the process for gathering more evidence. Now finally, the VA prepares for notification. They put together the entire claim decision packet for mailing, and they send it to you by U.S. mail, and it includes the details of the decision or reward. So after all of that, what if you're not happy with the initial decision? It's not the end of the process. You have options. And this is often the case. Veterans are either rated lower than they feel that they should have been, or not for all of the conditions that they filed for. So at this point, supplemental claims or higher level review can be done. Now we encourage you, again, contact your local CVSO to discuss your appeals options. They are easier than they used to be, but they're complicated. So never give up after you receive your first decision, and continue to file appeals of the initial decision. So now we have the Appeals Modernization Act. And this is what I was saying, where it's simpler than it used to be, but this whole process is still complicated. So get help from that CVSO or that volunteer attorney, pro bono group, or others that you can find on the CalVet website. So the higher level lane means that you don't have more evidence, but you feel that they interpreted the evidence improperly, or they interpreted the rules improperly. So you and your representative, your VSO officer, are going to argue how they should have interpreted it all. The supplemental claim lane, now this means that you are going to add more material. The appeals lane, which goes to a full appeal, the full process, and ultimately, perhaps, the United States Court of Appeals for Veterans Claims. Now, these are the areas, again, where you really want to get that assistance, because it is a legal determination. So, to repeat and repeat and repeat, don't do it alone. Seek assistance. It's free. It's really important. See the documents for more information and links on how to get that representation and assistance. All of those resources are on the CalVet website, and there's assistance all throughout the state of California. So thank you for joining us for this module, Filing a Claim, and we wish you all success.